Hello, 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 hello. I am live and we are going to go over the U.S. Citizenship Act of 2021. We are actually going to go over the summary. We have a really good summary on it and somebody actually wrote it. We have to give him credit for it and I'm going to go over it. But before I go over that, let me just give you some housekeeping first. Okay, first thing first, we have a new phone number. It's going to be available on March 1st, Monday. I will communicate with you as far as my new phone number. Remember, I talked about it that I was going to change services. So I am going to communicate with you my new phone number on March 1st, 2021. Just stay tuned. In the meantime, you can email me for consultation. My email address is right there on the screen. Please be advised that consultation fees apply. I do charge $175, okay, for consultation fees. And office hours till Monday to Friday, 8 a.m. to 6 p.m. unless we have a holiday or a personal vacation, okay? And basically on appointment only. So you call for consultation or you email at this moment, email only, because my new phone number will be available on Monday, March 1st, 2021. And tomorrow I'll be live again. I'm going to go over the ban. We all know that both bans have been lifted. I'm going to go into the details. Okay, so let's get right into it. What we have today. Today we have to talk about the summary of the bill. Somebody actually wrote the summary of the bill, and I'm going to go point by point. It's going to be very interesting, especially in the family-based category, because I did a employment based and I did it really well. Like, it's really so detailed. If you missed it, just go back to my other previous videos after this live. I'm gonna leave the link in the description box for employment based. Tonight we're going to do actually this afternoon is 3:30. We're going to do only employment based. Okay, let's get right into it. Let's start with what the representative Linda Sanchez said as far as critics are concerned, how they're defending themselves. Just listen to it, and then we'll go back and talk, and then I'm gonna go over the summary. Okay, just one moment. I'm sharing my screen, just one moment.
Democrats have the House of numbers, slim numbers in the House and the Senate, and you have the White House. Which of those things really gives you the better chance right now, you think?
It's actually a combination of things. I will say that this bill finally fixes our broken immigration system that is broken from top to bottom. And the American people understand that the status quo is untenable, that we need to fix this. And we have the right set of circumstances. I think after failed, chaotic, and cruel policies of the last 4 years, the American public are hungry for this. And because we do have a Democratic majority in the House and in the Senate, and a president and an administration that's willing to put some political muscle behind getting this across the finish line, I think everything is aligning. So we have a really great chance to get broad relief passed.
What is, name one or two things in here. Certainly the pathway to citizenship, I assume that's at the top of the list, but is that one of those things that if most people don't, most people should, you say, should love about this bill?
Sure. So it provides a pathway for folks to adjust their status into a legal status for people who've been living and working here for years, if not decades. I mean, many of the folks who would get relief in this bill are folks that we call essential workers. They are the ones that kept our economy running during the worst pandemic we've had in this country in 100 years. They're folks that made sure that when we went to the grocery store, there was food on the shelves. They're folks that worked in the transportation and energy sectors. They were frontline nurses and doctors caring for people with COVID. You can't, on the one hand, call them essential and then say somehow that they damage this country.
Right.
Secondly, this bill takes a novel approach to our southern border by investing in all of our ports of entry in infrastructure and technology that will make us more secure. And finally, this bill seeks to address the root causes that force people to flee and take that dangerous journey north. If we can reduce violence, corruption, poverty, hunger in Central America in particular, we will stem the need for folks to flee and come north in search of safety and security. So this bill works in conjunction with the international community and with the private sector to make those investments so that we can get at those root problems, because if you don't, we will continue to see that migration flow.
And I want to give you a chance to respond to some of the criticism on that point about trying to stem that flow of folks coming north across the border. There are critics who say, well, actually, you're putting this immigration bill in place and you're giving a pathway to citizenship. That's just going to encourage more people to actually try to get into the country. And another criticism, this is going to hurt American workers. Another criticism is that as you talk about the technology at the border, some just consider that a more high-tech wall, if you will. So I want to give you a chance here to address some of those concerns and criticisms that people do have of the bill.
Sure. So this bill only applies to folks who've been living and working in this country. It doesn't apply to new people that arrive. Number two, as I said, many of these folks have been living and working in our communities for decades. They are essential workers. So they're not stealing American jobs. They're already here. They're already working and contributing to this country. With respect to technology at the border, we spend billions of dollars on our southern border, and we had a president, the last occupant of the White House, who was fixated on the idea of a wall and barriers. Really, that's like a medieval solution to a modern day problem. By investing in infrastructure at our ports, we can crack down on bad actors. By the use of technology, we can do it more efficiently without having to spend those billions of dollars. And with respect to getting at the root causes, we will allow for in-country processing. So folks don't have to make that dangerous journey north. They can apply for asylum if they're being persecuted from within their home country and get a decision before they make that journey north to come to the United States.
And no small thing here. I am sitting here talking to the daughter of Mexican immigrants who's now leading the charge on Capitol Hill for an immigration reform bill. That's it might give some people chills. What does it do for you?
Yeah, it's really humbling. My parents are both immigrants from Mexico, and they sacrificed and worked hard to give me and my brothers and sisters opportunities that they never had. They put everything on the line, and we.
Okay, so back. Okay, I am back. As you can, you heard it yourself. Her defense is really good. As far as essential workers are concerned, that's a broad category of people working in stores, people working in the transportation department, people working as frontline, as nurses, or just medical professionals, stuff like that. So they're already here and they've been working already. So they're not really stealing anybody's job because they've been here and working already and paying their taxes already. So if this bill passes, this is a really great opportunity, and they have a great defense. And she said that circumstances are just aligned so that this bill can pass because they have majority in both. So in the Senate, it's 50-50, but they have majority in the House. So, and basically all sets of circumstances are right so that this bill can pass. We hope that the bill can pass. And we really think that this bill is going to pass, if not in its entirety, at least some portions of this bill will pass, okay? Let's now go to the summary. The summary, somebody else wrote it. We have to give credit, but the thing is, it's so well done. especially for the family part. I remember I did the employment based summary, which I did it really well as well. But this is basically family based, okay, immigration. If you miss the employment based summary that I did, I'm gonna leave the link after this live in the description box. And it's really, I guess it's one of my, not the last one, but before the last one. One of my last live, I guess, the last live, okay? That was when I did it. So let's share the screen and we're gonna talk about this bill like in a way that it's very understandable, what's in it, what to expect, and some of those questions that you have been asking me can be answered as well, okay? Let's get right into it. So let me see if I can put it bigger. Yeah, it's big now. I think you can see. So the summary was written by Greg Siskind. So basically it's well written. It's the U.S. Citizenship Act, the Biden immigration bill, and we are going to go over it. I highlighted a couple points. So just bear with me. We're going to go over it step by step so that we will finally get a better understanding and move on and just wait for a breaking news, okay? If something happens to it. So as we know, the bill states its purpose. The purpose is to provide an earned path to citizenship, to address the root causes of migration and responsibility, manage the southern border, and to reform the immigrant visa system, and for other purposes. The bill has 353 pages, but they consider it shorter than previous versions. Okay, but I think it was big. But anyway, they considered this is a shorter version. But let's go with what's in it as far as family base is concerned. The first thing first, they're changing the terminology. Instead of saying alien, they're going to use the term non-citizen. Okay. Then we have this earned path to citizenship and other reforms. So what is it? How is it going to work? It says the people who are going to apply for that pathway to U.S. citizenship, you are going to be called lawful prospective immigrant, so that you're going to get a LI status, okay? LPI status, okay? And then it says spouses and children don't have to submit a separate petition. This is really good. Remember with a Form I-130 for petitioning for relatives, you have to submit for each relative one application. So let's say you have 4 people coming, each person has to file, you have to file a form for each person, and that's a lot of money and a lot of cost as far as attorneys' fees are concerned. So, but in this case, this particular pathway to citizenship, spouses and children do not have to submit a separate petition. Really good, something to know. Okay, and then what does the lawful prospective immigrant, LPI, is a 6 years of status, which consider a lawful presence, and unless revoked, then you can extend it for additional 6 years terms if the LPI remains eligible, pass the background check, and the status has not been revoked. You have a card, and the card will be valid for 6 years. Okay, and that will be considered lawful presence. Okay, but you will not be eligible for certain benefits like tax credits and ACA benefits. So you'll be authorized to be employed, and you are authorized to travel with the LPI document. So basically, you don't need to apply for a separate travel document unless your LPI card gets lost, stolen, or destroyed. That's when you have to apply for a travel document to travel. But the travel, remember, is limited to 180 days. If you go longer than that, you have to get authorization. People know that. People who have lawful permanent resident, they know that when they go outside of the country for more than 6 months, they have to apply for reentry permit. So it's pretty much the same thing. So you be granted social security numbers, and you can join the U.S. Armed Forces if you choose to do so. And then after that, now they're talking about how are you going to adjust your status. So you can adjust, this is the conditions, you can adjust the status. The applicant still meets the LPI requirement and passes the background check and pay fees, submit an application under special procedures, has been an LPI for at least 5 years. Remember, the LPI card is valid for 6 years, but after 5 years, if you're eligible, you can apply now for your green card, okay? And you've not been absent for more than 100 days. We talked about it previously. And then ground of inadmissibility under section 212A previously waived won't apply. So basically, if you, let's say you know, certain people are not eligible to adjust their status, so they have to actually apply for a waiver in order for them to be able to adjust their status. But in this case, they say if you previously already waived that, it's not gonna apply. Like basically, it looks like it looks like you have to file for a waiver if you need to apply for the status, if you are required to file for a waiver. And then you have to pay all federal taxes, okay? Now they're talking about the DREAM Act. Remember this famous DREAM Act. Remember, we keep saying if the entire bill doesn't pass, at least we have the DREAM Act and the Promise Act. So what is it in the DREAM Act? Those are the requirements. The lawful permanent resident status may be granted to non-citizen if the non-citizen, that's the DREAM Act. The DREAM Act people are like people under DACA or people who came here under 18 years old. They are going directly to apply for the lawful permanent, for a green card. They're not going to get the LPI. Instead, they're going to get a lawful permanent resident directly, okay? I mean, provided that they meet those criteria and apply. So basically, you satisfy the eligibility requirements, you submit an application, you were younger than 18 when you enter the country initially, you have a high school diploma or an alternative like a GED, or you have obtained a college degree, and pretty much they're going to look at your work authorization and your earned income for the last 3 years, and then you have registered for selective service if you're required. That for basically DREAM Act. And then it says the above requirement can be waived if there are compelling circumstances showing an inability to satisfy them. So if you, let's say that those 6 requirements, you don't meet all of them, you can apply for a waiver, and it's at their discretion to decide whether they can waive it so you can be eligible for a green card. And it says spouses and children of people eligible to adjust under the DREAM Act can also adjust. Let's say you have a child who's actually already 21 years old and they want to apply for, after they get their green card, or they cannot, they can, when they adjust, they can petition for you as well at the same time. So that's for spouses and children who are eligible under the DREAM Act. So if your husband has a DACA, I mean, let's say your husband is eligible for under the DREAM Act, you are not, then the husband will apply for you at the same time. So basically, your name will be in the application, and you can be able to adjust your status as well. That's really good. So basically, when you qualify, you can adjust for your spouse, your children. Spouses and children, not parents. So parents is going to come later. Sorry, my mistake. Only spouses and children. But remember, if you have a green card and then you become a U.S. citizen, then you can actually apply for petition for your parents. Sorry, my mistake. So only spouses and children, okay, that are eligible to adjust their status if one of them is really under the qualify under the DREAM Act. Okay, so we move on. It says that the rule bearing DACA recipient from accessing the Affordable Care Act, that's the Obamacare, are being rescinded. So basically, you can have the healthcare thing. So, and you can have access to Medicaid and CHIP under this DREAM Act. Okay. And the 5 years requirement to get Medicare is going to be erased, and you're going to have access to all those benefits once you adjust your status under the DREAM Act. Now we move on to the American Promise Act. That's for TPS holders and DD recipients. Okay. DHS, the Department of Homeland Security, may grant LPR status to non-citizens who meet the requirement, submit the application, has been physically present since January 1st, 2017. That's the requirement for TPS holders and DED. That's pretty much Liberia. And is a national or foreign state, last habitually reside in such foreign states with a TPS or DED designation, and spouses and children are eligible as well. This is a good one too. Spouses and children are eligible as well, just like under the DACA DREAM Act. Remember, the DREAM Act is for DACA recipients and including people who were brought in the U.S. illegally under the age of 18 years old. So, and this, it says, it clarifies that TPS recipients are considered inspected and admitted to the U.S. under Section 244F4. So it clarifies that. So basically, you will be eligible to adjust the status from TPS and become a green card holder. And now we have the Agricultural Workers Adjustment Act. And this one is for, you see, for certain agricultural workers. And those are the qualifications. You meet the requirement, you submit an application. It determines that during the 5-year period immediately preceding the date on which the non-citizen submits an application under the section, the non-citizen perform agricultural labor or services for at least 2,300 hours or 400 work days. That's the requirement if you are under the Agriculture Act. Spouses and children are eligible and they don't have to meet the work requirement. This is really good. So spouses and children can adjust and they don't have to meet this work requirement. And then it defines define who is agricultural labor or services. What is it? It has the same meaning as used in H-2A visa. So pretty much just Google it. So it says means agricultural employment without regard to whether the work was seasonal or temporary. So that's for that. And those are just general provisions relating to adjustment of status. Okay. It says DHS may limit the maximum fee payable by a family and also waive the fee for good cause. Remember, if you have a lot of applications. As far as the pathway to 8-year pathway to citizenship, only one application can be submitted. But for other things, maybe you have to submit multiple applications, so they might waive the fee for good cause. So, and then it says you have to have been in the US as of January 1st, 2021. Okay. So those are just general provisions. It says non-citizen who move on or after January 1st, 2017, who were physically present in the US for at least 3 years prior to that may apply if DHS waives for humanitarian reasons. Let's say I had this question, somebody actually emailed me about saying about that she's still outside the United States, she has been deported and her kids are still here. So what can she do? So basically under this bill, eventually, even if the bill is not there, you can still apply for a waiver, provided that you've been granted a waiver. But this bill makes it really easy in terms of they can waive it for humanitarian reasons. So you don't have to prove like hardship, extreme hardship, which is a strong standard, like a burden of proof is very high with extreme hardship. So they can waive it for humanitarian reasons. And that makes it a little bit much easier. And then they can ensure family unity. So this is really good. And it says, or a waiver is otherwise in the public interest and the person hasn't re-entered the US illegally after January 1st, 2021. So if you have been deported on or after January 1st, 2017, you can still be qualified under this bill to re-enter the US, provided that the DHS give you a waiver for humanitarian reasons, and provided that you never re-enter after January 1st, 2021 illegally. Okay? So that's really good as far as general provisions are concerned. And then this one about grant for ineligibility, it says that felony or 3 misdemeanor, excluding possession of marijuana, national security, non-citizen smuggling, draft dodging, international child abductions, renunciation of US citizenship to avoid taxes. So waiver available for humanitarian reason, family unit, or if in the public interest, a crime within the last 10 years. So they can mitigate those crimes, basically. Just pretty much they're saying that they can reconsider those things, okay, under this law, under this new bill, if it becomes law, of course. And then putting aside H2A spouses status, eligible are accepted, as well as those engaged in essential critical labor or services during the COVID emergency. This is when they're talking about essential workers, and it's broadly defined: essential critical labor or services during the COVID emergency. Pretty much when COVID, some people were working from home and some people were required to just be on the site to work, and they couldn't do it any other way. So I believe those people are considered essential workers for the purpose of this bill, because it's broadly defined, as you can see here, okay? And it says this exception was incorporated in the HEROES Act and is a very broad list, and COVID is tied to the date the emergency was declared by Trump until 90 days after the public health emergency declared over. People who work during this time are considered essential workers, and they will be, if they don't have documents, be qualified under this bill. Okay? And then we have other reform. V visa holder will be employment authorized and must have an endorsement or an EAD. The V visa is the people who actually, let's say your spouse has a green card and they petition for you and you get to the US, you come under the V visa to wait for that petition to actually get to its final course. And in the meantime, you can apply for work authorization and be able to work. That's what they're saying here. Okay. But you will not be eligible for any means tested public benefit, like let's say public benefit, employment or food stamps, all those public housings and all those public benefits. You're not, even the qualified health plan, tax credit, you're not going to be qualified for it. Okay. And then this here talks about expungement and sentencing. Basically, the purpose is the definition of conviction for immigration purposes is changed to no longer include any adjudication or judgment of guilt that has been dismissed, expunged, deferred, annulled, invalidated, or withheld or vacated. So this is really good. Remember on the application when they ask you, have you ever committed a crime, even if the crime has been sealed, or even if you were cited but not convicted, you have to just say yes and explain. But under the new law, if the bill passes, you will no longer require to put yes on that conviction if the judgment of guilt that has been dismissed, expunged, deferred, annulled, invalidated, withheld, or vacated. So you no longer have to put guilty or something like that. Okay, then we have petty offenses. Offense exception is modified to allow for 2 crimes if the minimum penalty for each did not exceed 1 year and the non-citizen wasn't sentenced in either to more than 100 days. So those are petty offenses if you were not sentenced for more than 100 days. Okay, so and then they're gonna restore fairness to adjudication. I'm not sure how they're gonna come up with this one, but yeah, that's what they're aiming at. And yeah, this one, I want to talk about this one, modification to naturalization provisions. Remember, it's being amended to reduce from 5 years to 3 years the residence requirement for those LPRS, lawful permanent resident, who for at least 2 years before becoming the lawful permanent resident were both legally present and eligible for employment authorization. So instead of waiting for 5 years after you get your green card, you can only wait for 3 years. That's what it's actually saying here. So if this bill passes, of course. Okay. And then what else we have here? Expanding refugee and asylum processing in the Western hemisphere. So basically they're gonna create a lot of centers in the Western world, so where you can just apply for asylum from there, and once your asylum get processed, then you just get here. So that looks good. Okay, I think for family, that's it. Oh, sorry, I have it here. So they are going to reform the reform of the immigration visa system. They're going to promote family reunification. You see, they say FB cap from jumping from 226,000 to 480,000. Okay, and the employment base, which I talked about already, jumping from 100,000 to 170,000. Starting on the fiscal year, which starts on October 1st, 2021. Okay. And the F2 category, people ask a lot of questions about F2, F4, F1. F2A category, spouse of minor children or permanent resident, becomes an immediate relative category. So basically you become a first degree relative. And then we have adjustment of family sponsor per country limit. per country limit raised from 7% to 20% and from 2% to 5% for dependent area. This is really good for family sponsor. Really promoting family unity, repeal the 3 and 10 years bar for overstay of 100 days or a year. Making a false claim to citizenship is not the ground of inadmissibility or ground of removal if the claim was made before the age of 21. This is really good. A lot of people have asked about those waivers. This is very clear what they're saying. They're saying that they're gonna remove that waivers, the bar. So they're gonna remove that bar of 3 and 10 years bar, and then making a false statement, as long as it was made under the age of 21, is not going to be the ground of inadmissibility. Okay, so this is really good. And somebody asked me about widow. Okay, this is what they're talking about, widow, ma'am. It says that non-citizens who were immediate relatives, like you became a widow, family sponsor immigrant, derivative, beneficiary of the spouse, child of a refugee will have their immigrant visa adjudicated as if the death had not occurred. Okay, if the death occurs before the effective date of the section, a motion to reopen will be permitted without a fee, and the bars to entry will not apply. The immigrant visa will remain valid after the death. So you are the one who were talking about being a widow of a U.S. spouse. So your case got denied. What are you going to do under this bill? They said that you can reopen the motion. So depending on the reason, really actually got denied. But if this bill passes, you still have the right to reopen the motion, and they can adjudicate it as if the death had never occurred. So this is really good provisions, because sometimes when somebody passed away, they say the application dies with the person. But this is going to give a lot of hope, especially for family-based petitions, especially for the people, siblings, when they apply for the siblings and stuff like that. But this is specific to widows and orphans. I hope they have something else for siblings. But anyway, they only have for orphans and widows. So children and spouses. So naturalization application will continue to be eligible to naturalize after 2 years, even if this USCIS spouses has died. This is really good. And then Filipino has an exemption here, say exemption from immigrant visa limit for certain veterans who are natives of the Philippines. So basically, those eligible in the F1 or F3 family categories who have a parent who naturalized as a Filipino veteran are not subject to numeric limits. So you can still apply, no limits on the cap. And then the fiance or fiance child status protection. So basically, so freezes a K2 child age on the day and is filed. So basically, the child would not age out. It freezes the age on the day I-129F is filed. Remember, we talked about aging out. You can go back and watch my previous video, but this gives you clarity, really. Okay? As it says, protect minor child of K1 from aging out, so pretty much. And then retention of priority date, non-citizen who age out of F2. So they are going to go with following the joint, keep the original priority date based up receipt of the original family-based or employment-based petition for which either parent was a beneficiary. So they're going with the date of filing the petition. Okay. So pretty much they're trying to protect the child, aging out of the child. Okay. So, and then definition of the child, we know that allow stepchildren and children of non-citizen permanent partner to qualify as a child if the child was under 18 when the permanent partnership was formed, if the child is adopted by the non-citizen permanent partner while the child was under 16. So I've talked about those age, how they determine age in aging out. So the stepchild is considered child if the marriage was done when the child was under 18. The adopted is considered adopted if the child was under 16. So when the adoption occur, okay? So yeah. And then we have increase of diversity visa. I like this one. That's how I got in the US with a diversity lottery. So from 55,000 to 80,000, really good. Reforming the employment-based immigration. I talked about this doctoral STEM graduate. They have the opportunity to stay. They're going to address visa backlogs. Okay. I think the other one is about employment based, which I really talked about it in details. Okay, let me stop sharing and come back here. So we got it, my friend. This is a long live stream, but we went over all the pretty much we summarized it. Okay, we did summarize everything. This is the most I'm telling you. Let me go to the comment first before I hang up and see what they're talking about here, if I can answer some questions. But we did summarize the bill, and those are the main points. We talked about employment based last time in detail, and now we have been talking about family based all along, but today we did some details to it. And my friend, that summarized everything we've been talking about. So if you don't have clarity, I don't know what else I can do. I can say, because I really went into details with those bills. And from now on, we just have to wait for a breaking news, a major news, what's going on in the Senate now with the bill. And once we get that, that's it. That's when we will actually come back here to talk about those bills, because we have to move on to other subjects, especially in March. And tomorrow I'll be live talking about the proclamation 10014-10052. Let me go back to the comment, and then I am going to end this live stream. Let me go back to the comment. It says, thanks for all the help you're giving for all immigrants. Thank you. That's for Tommy Louis. What about TPS holder? We talk about TPS holder is in the Promise Act. So they have a path to a green card. So they can apply for a green card directly, they don't have the same path as undocumented, because they are under TPS. So they already have a legal status, temporary legal status. So now if this bill passes, especially the Promise Act, so they can apply for the green card. So hello, James. I have a question. What's your question, James? Hi, Eddie, Lucy, Jason. Hello. If the Biden amnesty bill pass, will there be any waiver available for marriage fraud who is currently in the U.S. in TPS status? They talk about waivers as far as waiver for, I'm not sure if you're barred from 10 years or 3 years, depending on what type of bar you have for adjustment of status, but they're talking about waivers that you can apply for waiver. But remember, the waiver is still going to be under the discretion of those of the DHS. So can I visit my home country now? Can return the US to LPS once approved, being stay here since. Yeah, if the LPI, you can visit, but remember, that's for Monaco. You can visit, but remember, you don't have to stay there for 100. You can only stay there for 6 months. If you want to stay longer, my friend, you have to get a permission. So This is Maridia. I was 17 when I came to the US. I'm currently on an F1 visa. Do I qualify under the DREAM Act 2021? F1 visa, if your visa is current, then you are not undocumented. I'm not sure. This is for Maridia. I'm sorry if I mispronounce your name, but if you're currently on a visa, it means you're not illegal. So I am not sure if you will be qualified. To be honest with you, this is something we're going to have to debate, because if you're currently on an F1 visa, it means you have a visa that is current, it's valid, and unless the visa expires, okay? So that's how I can answer that. Hi, what about 3 year and 10 years bar ban for inadmissibility? This is for Space. Hi, Space. So this one, they're talking about it too. They're talking about there will be waivers. They're going to remove the bars, especially for minor crimes. That's what they're saying. They're going to remove the bars, and you can give, they will give a waiver. They might consider waiver for humanitarian reasons, okay? Which is good, because the waiver for, to prove hardship, it's kind of difficult, but if it's for humanitarian reason, it's much the standard is going to be lower. It's going to be much easier. This is for Pantor. I came here as an F1 student, dropped out. I am out of studies. Is there anything? Yes, if you're out of studies, yes. As far as your out of studies happen on either on January 1st, 2021 or prior. So you'll be qualified because you consider undocumented. Will person granted medical defer action green card? Will person? I don't understand that question. Will person who previously had medical defer action be granted green card? Medical defer action. I did not see anything on that, to be honest. Alicia, I did not see anything about medical defer action on it. But the thing is, if you are undocumented, let's say you have no status, as of January 1st, 2021, you are part of this big bill. Being granted withholding of removal is same as status as no. My friend, granted withholding of removal has a lot of limitation to it. It is not comparable, because granted withholding of removal simply means that they gave you permission to stay here legally with some limitation to it. You have travel document and you have a work permit, but your path to a green card is not clear. You do not have a clear path to a green card. So your case, if this passes, it's going to be challenging for anybody who will take up your case to argue for you so you can get a green card. If you have been denied to us, you will be a yes, because if you're undocumented, yes. TPS, DPAC, TPS, we talk about it, it's the Promise Act, so they're still included. Yes, someone with pending asylum, we've talked about it. You're undocumented, yes. When you are qualified to new law, if the law passes, when they change state, will your document be removed or what? When you are qualified to the new law, if the new law passes, okay? When you change status. I don't understand this question, Comlan Aguti. I don't understand your question. When is the House supposed to vote for this bill? Apparently, the House has already passed the bill. It's in the Senate. The problem is the Senate, not the House anymore, from what I know, unless I'm wrong. Marie just said we are in the dream right now, unless it becomes a yes, ma'am, we are in the dream. But dreams do come true sometimes. I had a dream and now it's true, I'm here. So if some portion of the bill passes, eventually some people will get something. You don't, if your case is in New York, you're the one who need to do the transfer to Texas. They're not going to transfer the case for you. Comlan Aguti, they will not transfer the case for you. You have to do your own transfer yourself. You have to change venue, file a motion. Why now? Oh, okay. Why now asylum? You have to wait for 1 year before you get a work permit. This is the new law. As if you apply after sometime in August, I guess August 20, 2020, everybody after that have to wait for 1 year. What about countries that depend on you? Not sure what you mean. How long need to wait for this piece? But they're talking about by April 1st, we should know something, or April 15th. At least we will know if it will pass or not. We will know something. Just look at April 1st or April 15th. Yes, the U visa, they've increased it to 30,000 cap, I guess. Somebody has been selected for DVD lottery. This is for Sila Aliyah. Hi, Aliyah. Someone has asylum case in the immigration court. If he has been selected to lottery DVD, yes, you can adjust your study to the green card. If you've been selected for immigration, for DV lottery, but you have to double check about the waiver if you have to apply for the waiver as well before you adjust to a green card. That's the part you have to check out. But yes, you can adjust using the form I-485. Okay, if you win the green card, you are here. You can do that. You can adjust your status. Siddiq, yes, you can apply if the bill passes. Yes, if you have a LPI status, you can go home, but remember you cannot stay longer than 6 months. You can apply for your spouse, but remember it takes time for your spouse to get here as well. The same processing time with visa. Okay, overstay cousin had cancer and needed help. Okay, hi, please. Oh, hi, please. What about who has the student visa not expired? You are not undocumented. If your student visa has not expired, you are legal. So the only people who benefited from this is people who with advanced degree in STEAM advanced degree, like engineer, people in the mathematics, technology with PhD, they can apply for a green card. And they said that they're going to extend the OPT as well. I have pending asylum case. Yes, will be eligible. Pending asylum case. Yes, will be eligible. Thank you, Tracy. Thank you very much. I do appreciate you too being here on live on a Saturday. Asylum seeker, depending when you got in the US, because it's like as of January 1st, 2021. Thank you very much for your answer. What if I-94 has expired to those who qualify? I-9, 194. Are you talking about I-94 or Y-94? What is your current status? So basically, if you're undocumented as of January 1st, 2021, you are qualified. Okay, we answered almost all questions, and I thank you for being here on a Saturday afternoon. Please comment again if you want, but we answer all the questions. I don't think I'll go back to those questions, especially today. I did answer all these questions. Just share this video, share it with your friends, and I guess I'll see you next time. Remember, my phone number has changed. I will communicate with you the phone number on March 1st, which is a Monday, 2021. And tomorrow I'll be live to explain the proclamation ban, the ban that has been lifted, what it means to you, the details. And I'll be live here maybe around 12 or 1 p.m. in the afternoon. I'll do another live, but thank you, or maybe later. So yes, they will remove the ban for 10 years. Okay. Oh, what is saying? They have given me a final approval for my asylum with my children who stay in my country. Oh, the processing time for pending, it can take up to 18 months. Grace, it can take up to 18 months. So, okay, document early 2020. When will say confirm? I don't know. You just need to be patient with this process. A lot of backlog, so just be patient with this. That's all I can say as far as processing time. Okay, I'll talk to you later. Bye-bye. Bye-bye. Work permits, depending on when you apply. Expired B2 visa, depending on when it expire. If expire as of January 1st, 2021, then you'll be qualified. Okay, that's the cutoff date, January 1st, 2021. Thank you, and I'll talk to you later. Bye-bye.